morning. It's wonderful that you're here. I want to welcome our online audience, but also our live audience to the 9th edition of the Live Panel event. My name is Rosa Sedorio. I'm actually Associate Dean for International and Comparative Legal Studies at UW Law School. And I have to say I'm very grateful to the Office of Legal Advisor of the State Department for being here, for the ABA section of International Law, and this wonderful collaboration we have with them. Also the American Society of International Law, who's represented here. And I want to actually share a special thanks to Ron Bettauer, who conceptualized this event, I understand 9 years ago. And this is a wonderful forum of discussion of contemporary issues in international law. We think it's a very special occasion at UW Law School, and we feel very privileged, Ron, to be collaborating with you on this event. Before discussing a little bit the topic that we're going to be addressing today, and also introducing Jennifer Newsted, the legal advisor, I just wanted to clarify that we will be receiving questions from online viewers during the program. The address is livefroml2019@gmail.com, but also from the live audience. We will open a space for questions. And I think there's something really interesting this year in terms of the topic selection. International economic law is not only a timely topic to discuss right now, but I think it's also one of the most fascinating, complex, and dynamic areas of international law. Very fast developing, and there's a lot of developments and changes happening in this area. And since we have a lot of students here, I just wanted to talk a little bit about what we mean by international economic law before we actually pass the floor to the State Department, right? At the end of the day, when we think of international economic law, we're actually thinking and referring to many contemporary economic issues with global dimensions and also international law repercussions. And at the end of the day, international economic law is many things. It really covers the variety of legal, policy, and institutional developments in key areas such as international trade and our multilateral trading system, the reform of investment dispute settlement, a variety of issues related to the transnational movement and regulation of goods, services, labor, and capital, and the role of many contemporary settings like cyberspace, like the internet, social media, and privacy concerns in this context. We're also referring to international business transactions. We have courses on that at UW Law School, but also economic growth, the building of productive and sustainable economies, and also exploring how all of these are connected to both private and public international law, but also how these can be connected to the environment, to justice issues, to human rights issues, and the human side things of the equation. And I would say at the end of the day that we're also thinking about the complexity of the interplay between government and non-state actors as well in this area. But without further ado, I would like to introduce Jennifer Newsted, right? She's the current legal advisor of the State Department. And prior to her appointment, she was a partner at the law firm of Davis, Polk, and Warwell, where she had a global practice representing clients in cross-border regulatory and enforcement litigation matters. She previously served in many senior government positions. She has so many accomplishments. She clerked for Justice Breyer in the U.S. Supreme Court and Judge Silverman of the U.S. Court of Appeals for the D.C. Circuit. And she's also a graduate of Yale Law School and Harvard University. And I think it's very important to also note that she serves a very key and paramount role in the U.S. government. She advises many senior government officials on matters of international law and foreign affairs. And I just wanted to say, Jennifer, that it's an absolute honor for GW, for you being here today, for always sharing with us your time, for being so generous with your wisdom and experience. It's really wonderful when you're here at the law school. And now I will turn to Jennifer Newsted.
Thank you so much, Rosa. And let me say, on behalf of my colleagues who are joining me today, and you'll be hearing from them in a minute, and on behalf of our office, this is a wonderful event. We're delighted to do it. We're very appreciative that the law school and the ABA and ASIL have all contributed to making this an annual event for us to share and discuss with you important issues of international law and the work of our office. So thank you all very much for joining us. For those online, thank you for joining us as well. We are looking forward to a stimulating and an interesting session. Let me just introduce the topic a little bit before I hand over to my colleagues. It's commonplace now to say that we live in an interconnected world, so it's no surprise that the economic issues we're going to discuss today are at the heart of many matters that we address now and that are addressed by the government, of course, more generally. Economic activity across borders was the impetus for the development of the law of the global economy, and the scale of that activity has grown over the years, and so have the legal regimes that are designed to make it more efficient, more free, and more fair. We all know there are a number of foundational multilateral agreements and institutions that form the legal architecture internationally for addressing these issues, and you're very familiar with those from the World Bank, the IMF, the WTO, and others. There's also a wealth of legal practice and legal authorities on which states and private companies rely for stability, predictability, and to facilitate cross-border economic activity. That includes, of course, the negotiation and implementation of international and bilateral agreements in a range of areas: investment, trade, aviation, taxation, telecommunications, energy. The list goes on. We'll touch on a few of those topics today. And it's critical to the United States and to our foreign policy and national security interests to tailor our economic relationships in important ways that are subject to those different regimes. It's quite simply impossible to imagine the world economy today without these multilateral and bilateral instruments operating. And at the same time, a critical part of our work in L is helping our policy leadership utilize US-based economic tools in furtherance of our objectives, whether that be the development and application of financial sanctions, which is a topic very much in the news that we're going to address today, the establishment of screening mechanisms for investment activity, or using our assistance authorities in strategic ways. Secretary Pompeo addressed these issues in a general way when he made remarks last year to the Detroit Economic Forum. And he said that economic diplomacy has always been central, when done right, to the State Department's mission, and that we use American power, economic might, and influence as a tool of policy to help America achieve its interests and promote our values around the world. At the State Department, there are a number of players who participate in these efforts, and they are our clients in the Legal Advisor's Office. They include the Bureau of Economic and Business Affairs, the Bureau of Energy Resources, and the 1,500 economic officers who serve in embassies around the world. Of course, we also act in partnership with other agencies in the US government, including the Departments of Treasury, Commerce, Justice, Agriculture, Energy, to name a few, as well as the US Trade Representative. So our mission today is to talk to you about how L is central to these activities and the broader mission of economic diplomacy, and how we use economic tools to advance our objectives globally. We have a very broad topic today. We could spend a year or more of a law school class discussing these issues, and mindful of the fact that we only have 90 minutes, we're going to leave some time for you to ask your questions and engage with us as we talk about each issue. So rather than attempt a comprehensive survey of the global international economic legal framework, we're going to divide our time into each of our four panelists addressing some specific issues that we've been engaging on, particularly in the last few years. And we have a team of L attorneys here today whose work touches on those matters. Let me introduce them to you now. Three of the four come from our Office of Economic and Business Affairs, which we refer to as LEB, and one from our Office of International Claims and Investment Disputes, which is known as LCID. We'll let them speak, and then we'll do our best to address your questions. So speaking first, we have Jesse Tampio, an attorney advisor in LEB, who's going to give you an overview of international civil aviation law and discuss L's role in supporting the aviation-related functions of the department. Aviation law is a fascinating example of the legal architecture that's crucial to modern life, but operates largely without notice from the general public. It's fair to say that without it, air travel, as we know it, would not exist. Next, we'll hear from David Sullivan, another attorney advisor in LEB. And David will address investment treaties and CFIUS, the committee that conducts national security-related reviews of foreign investment in the United States. There is a great deal of front-page news relating to these topics, the innovations in the investment chapter of the US-Mexico-Canada agreement, which is currently awaiting approval in Congress, and the administration's active efforts to implement CFIUS reform and legislation known as FIRMA to respond to new and emerging threats. David will touch on those matters. Then we'll hear from John Blank, an attorney advisor in El Cid, who will address the rich litigation and arbitration practice in El on investment matters. And John will discuss El's role in representing the United States in investment arbitration proceedings, both where we are the respondent in a proceeding and where we're not a party, but nevertheless will participate and offer our views. And last but not least, we'll hear from Emily Kimball, an attorney advisor in LEB, who will talk about El's role in advising on new and existing sanctions authorities, both domestically and at the United Nations. And as you know, successive US administrations, including this one, have increasingly relied on sanctions as a key element of US foreign policy, whether that be with respect to Iran, North Korea, Venezuela, or elsewhere. These regimes are tremendously complex, and for today, Emily's going to address that by focusing less on any particular regime and more on the types of cross-cutting issues that we address in El, as well as highlights for you of some recent developments in the area. So without further ado, let me hand over to Jesse to get us started. Jesse.
Do I have to thank you, Jennifer. As she noted, I'm going to be providing a quick overview of civil aviation law from a 40,000-foot cruising altitude. So you can't say you didn't see that coming. So to understand why this is a distinct body of law, some context may help. First, airlines, beyond just being significant economic actors, have long been a source of national pride. Many carriers serve, or started out at least, as flag carriers owned by their government, from British Airways to the lesser-known Air Vanuatu, which gets 4 stars on TripAdvisor, I found out. Air travel is a critical way that countries and their populations connect with one another for business and tourism, but it also has, civil aviation has an important national security dimension as well. Think the Civil Reserve Air Fleet, or the basic fact that you don't want to have to rely on other countries' airlines to get in and out of your own territory. All these factors have historically led to rather protectionist national policies when it comes to airlines and air services. And consistent with this history, air traffic rights are generally handled separately from other trade issues. And by air traffic rights, I mean the legal permission for one country's aircraft to fly over, land, or carry passengers or cargo in and out of another country. So the best place to start in an overview of aviation law is the International Convention on Civil Aviation, also known as the Chicago Convention. This multilateral convention was negotiated in 1944 to promote uniformity in national regulations, standards, and procedures governing international air transportation. It also created the International Civil Aviation Organization, or ICAO, a UN specialized agency, and Chicago now has 192 states parties. It codifies core principles like sovereignty over airspace and nationality of aircraft, similar to the way that all ships must be flagged. And moreover, it establishes the rules of the air, kind of like rules of the road, as well as rules for safety of aircraft, air traffic control, communication, environment, aviation security, and more. And it's a living instrument. Through ICAO, member states agree on what are called standards or recommended practices that comprise annexes to the convention. Standards are rather unique in international law. They're binding unless a country formally submits what's called a difference with ICAO based on conflicting domestic law or practice, while recommended practices are by nature non-binding. To provide a sense of the scale, the Chicago Convention now has 19 annexes containing some 12,000 standards and recommended practices. With all that, it's important to note what Chicago does not cover. First, its rules cover only civil aviation and not what's known as state aircraft, such as military, customs, or police aircraft. These are governed by a separate set of principles, which we don't have time to discuss today. Second, while it does address, along with a companion treaty from 1944, the right to overfly another country's territory, it does not otherwise provide for traffic rights. Rather, in line with basic principles of sovereignty, it codifies that scheduled and charter service must be authorized by the state of destination. So air traffic rights are not covered by trade agreements or Chicago. So how are they granted? This is largely accomplished through bilateral air transport agreements, or ATAs. I've heard the statistic that there are some 4,000 air transport agreements worldwide, mostly bilateral, but with a handful of multilateral ones. And this has led to pretty good job security for aviation negotiators. ICAO even convenes a yearly conference for aviation negotiators called ICANN. That's kind of like speed dating for aviation. So what do these ATAs look like? Pretty much all ATAs prior to 1992, and many still today, are called restrictive in nature. And reflecting the historic protectionism in aviation, they restrict the number of airlines each side can designate for traffic between them, how many of the other cities each can fly to, how many frequencies, and even allow governmental intervention on pricing. At a minimum, they allow for traffic back and forth between the two countries, say between my country and David's. The harder part of the negotiation is often whether they provide for additional traffic rights, which have been given the fancy name freedoms of the air. One would be the right to travel from my country to David's country and then on to Jennifer's country, which are known as fifth freedom rights. Another would be for my planes to carry traffic between David and Jennifer's country without ever touching mine, which are known as seventh freedom rights. And sometimes that's allowed for cargo, if you think of like FedEx operating between Europe and Asia, but it's very rare for passenger service. Realizing that this old restrictive model was hampering economic growth and connectivity, in 1992, the U.S. Department of Transportation instituted the U.S. Open Skies Policy, whereby we seek ATAs that eliminate all such restrictions on routes, frequencies, and pricing to let airlines make purely market-based decisions. Open skies agreements provide for unlimited fifth freedoms to allow for airline networks. Sometimes we're able to get seventh freedom for cargoes, carriers, and they also contain liberal, what are known as doing business provisions related to customs, ground handling, and other airline operations. I need to also highlight one other principle of ATAs, whether open skies or restrictive, and this is the concept of ownership and control. ATAs have historically required that the airlines of each side be owned and controlled by each country or its nationals. And one reason why is to avoid free riders. If I've negotiated a liberal agreement with David's country, but a restrictive one with Jennifer's, I don't want Jennifer to buy David's airline and then get a backdoor into a more permissive regime. In line with this, U.S. airlines, by law, have a cap of 25% voting stock by foreign nationals. And I would just note as a lawyer that what I find fascinating is the real three-dimensional thinking that it requires to unpack all these different rights and ownership restrictions when you're dealing with multiple countries and agreements. So coming back to open skies, you can imagine that some countries would have hesitation to sign an agreement with the U.S. That would allow U.S. airlines to openly compete with their national airlines, challenging that deep-seated protectionism. And one of our carrots has been antitrust immunity. In other words, an open skies relationship is a predicate for the U.S. Department of Transportation to grant antitrust immunity between U.S. and foreign airlines. Although airlines are very competitive, they also have a huge incentive to collaborate to increase efficiencies, but it historically been prohibited from cross-border mergers due to those same ownership and control restrictions I mentioned. So they came up with first code sharing and then more elaborate alliances, think the One World Alliance, Star Alliance, and Sky Team, and other forms of joint ventures. And DOT has been willing to grant antitrust immunity to such joint ventures to allow for coordination on pricing and routes, in part because an open skies agreement guarantees that new entrants can always join the market and discipline pricing. And because these international alliances compete with each other. That said, the concept of airline antitrust immunity has not been without controversy. And another benefit of open skies has been that the Department of Transportation has a practice of waiving these foreign ownership and control restrictions if all the countries involved are open skies partners, because no one's getting a backdoor. If I have open skies with both David and Jennifer's country, they can own each other's airlines and no one's getting a better deal than their own country had. So open skies then have a benefit of allowing for more foreign investment. So this open skies policy has been extremely successful over the past 27 years. We've established open skies with over 125 partners. Many other countries have adopted a similar approach. And it's so successful, many of you may assume it's always been this way. But I should note that we still have restrictive agreements with several countries, notably China and Russia. One recent example of an open skies negotiation was with the UK. While it remains an EU member state, it's covered by the Open Skies Agreement we have with the entire EU. But for when and if the UK leaves the EU, both sides have wanted a bilateral ATA ready to fill the gap as soon as that happens. So it took 18 months to negotiate an agreement. We finished it in November. And the main issue was ownership and control. Because several UK airlines that fly to the US are owned and controlled by not UK nationals, but other EU nationals, which is baked into the EU agreement. We ultimately didn't give the UK the same foreign ownership rights bilaterally as we had given the EU, but we ended up with a partial grandfathering of UK airlines. And when you combine that with the waiver process I mentioned before, you can rest assured that UK airlines will continue to fly to the US. So what's L's role in all this? Aviation's always been a busy portfolio, but it's grown so much over the last few years that L has expanded it from a one-person portfolio to where myself and a colleague, John Padilla, and I each spend about 75% on aviation. In recognition of the significant foreign policy equities of air services, State's Bureau of Economic and Business Affairs has an office that leads on air transport negotiations in coordination with Department of Transportation and Commerce, who are the domestic regulators. But that means it's a negotiation-heavy portfolio. In the last year, beyond the UK, we've had negotiations, including with the EU, Japan, Argentina, Belize, in addition to the annual speed dating conference. And we participate in every part of that process, negotiating texts, seeking the internal authority to negotiate and conclude such agreements, interpreting the agreements when we believe the other side is acting inconsistently. We also help interpret the Chicago Convention and help address issues related to ICAO. The Department of Transportation and FAA are the real subject matter experts on these standards, but we get involved in a lot of institutional issues, such as the dispute resolution mechanism under Chicago Convention, which is Article 84. There's one suit that Brazil brought against the US based on a 2006 mid-air collision over Brazilian airspace. And Qatar has brought a case against its 4 neighbors for imposing airspace restrictions. We also handle litigation. There was a DC District Court case related to Norwegian Air that involved a tricky labor-related provision of our EU agreement, and there was legislation that was brought forward related to the same issue. We also work a lot with FAA and TSA on their international cooperative or technical assistance agreements, and CBP on pre-clearance, which is where you can go through customs before you get on a plane to the US. So I've covered a lot of ground or airspace pretty quickly, but I'm happy to answer any questions during the Q&A. Thank you.
Thanks so much. And I think what we'll do is just, in the interest of getting through our presentations, we'll hold questions, and then at the end, we'll be happy to take them. David, over to you.
Great. Thanks very much, Jennifer. I'm going to address 2 areas related to investment. First, I'm going to give a brief overview of international investment agreements. That discussion will help set the stage for John's talk following mine about dispute resolution under those agreements. Second, I'll talk about national security screening mechanisms for investments, and I'm going to focus on the US screening mechanism, which is known as CFIUS. International investment agreements have been a source of much new international law in recent decades. One UN source counts 2,600 international investment agreements in force currently among all states worldwide. As John's going to say in more detail, the US currently has such agreements in force with 58 states. These US international investment agreements take one of 2 forms. They're either standalone treaty specific to investment, known as a bilateral investment treaty or BIT, or an investment chapter within a larger free trade agreement, such as the 1992 NAFTA agreement or its recently concluded successor agreement, the US-Canada-Mexico agreement. Whether these agreements take the form of a standalone agreement or a chapter of a larger free trade agreement, in substance, they all have a similar structure. Their key components are, first, a set of substantive investment protection obligations concerning how each state will treat investments from the other state, and second, a group of provisions on dispute resolution. So I'm going to use the USMCA, the recently negotiated agreement, as an example. In it, the key investment protection provisions include rules that prohibit the following: expropriation without prompt, adequate, and effective compensation, phrase that will be very familiar to you from your international law classes; discrimination; performance requirements, which include technology transfer and local content requirements; nationality-based requirements on the appointment of senior management; restrictions on the transfer of investment-related capital; and denial of justice and other breaches of the customary international law minimum standard of treatment. So that's a very brief summary of the investment protection provisions in the USMCA. They're updated with clarifying changes and modernizing changes, but they're very similar in nature to the same investment protection provisions in previous U.S. international investment agreements. The dispute resolution provisions in the USMCA, by contrast, are significantly changed from our previous agreements. State-to-state dispute settlement remains, but the investor-state dispute settlement with respect to Canada is phased out completely, and with respect to Mexico is narrowed in certain important ways. If anybody's interested in the details, I'm happy to address that in the Q&A, but I'm going to try to move on in the interest of time. John's going to say more about state-to-state and investor-state dispute settlement cases and how we address those. I'm going to turn to my second topic, which is investment screening. The Committee on Foreign Investment in the United States, or CFIUS, reviews foreign investments in the United States. It assesses their impact on U.S. national security, and it takes any appropriate responsive action. So CFIUS is an interagency committee. It's chaired by the Treasury Department. Other agencies that are members of CFIUS include, I'll say the Department of State first. I had them in alphabetical order, but I'm going to include us first. Also, Commerce, Defense, Energy, Homeland Security, and Justice, as well as the Office of the U.S. Trade Representative and the Office of Science and Technology Policy. There's also the Department of Labor and the Office of the Director of National Intelligence, which are non-voting ex officio members with roles that are specified by law. Certain other White House offices observe and participate in the CFIUS activities. So it's a large segment of government agencies that are members. The operations of CFIUS are currently changing. Jennifer mentioned the new statute called FIRMA, which was enacted in 2018. It's currently being implemented, and it modernizes the committee. So I'm going to first talk about how CFIUS worked before that statute until 2018. For convenience, I'm going to call that traditional CFIUS. Could have called it classic CFIUS, but then I'm going to talk about the changes that were brought about by FIRMA. In traditional CFIUS, under the law up before 2018, CFIUS is able to consider any transaction in which a foreign person acquired control over a U.S. business, and control is a key word there that will come up later. The parties to the business transaction can report the transaction to CFIUS on a voluntary basis. And again, voluntary is significant in terms of what FIRMA has done since then. And I'm also going to explain a little later, the law creates an incentive for the parties to voluntarily file. CFIUS can also decide to initiate its own filing, separate from the voluntary filing of parties, under a process for what we call non-notified transactions. In either case, CFIUS analyzes the transaction under a strict statutory time frame and determines through interagency review and deliberations, which are generally classified and further protected against disclosure, whether the transaction poses a risk to the national security of the United States. So the strongest possible sanction that can come out of this deliberation is prohibiting or unwinding a transaction. The CFIUS statute gives authority for that sanction to the president upon a referral from the committee, where the president finds that the transaction, quote, threatens to impair the national security of the United States. Such a presidential block has occurred on only 5 occasions in the more than 30-year history of CFIUS. although when I state what years those 5 occasions were, you might detect a trend. It's been 1990, second was 2012, third was 2016, fourth was 2017, fifth was 2018. I mentioned before the law creates an incentive for the parties to file a transaction with CFIUS. There's a provision in the law which we call a safe harbor. It states that after CFIUS has determined that a transaction may go forward, which is the ultimate result of most CFIUS reviews, with few exceptions, CFIUS cannot later prohibit or unwind that transactions. So parties who do not file notice of the transaction with CFIUS lack that safe harbor, and the president could later order the transaction to be unwound even well after it occurred, a risk that businesses would rather avoid. That's the incentive to file voluntarily. In recent years, concerns arose about business transactions that, possibly by design, did not receive review by CFIUS, in some cases leading to possible foreign acquisitions of sensitive leading-edge technologies. To modernize CFIUS to address these concerns, in August 2018, Congress enacted and President Trump signed into law a statute known as FIRMA. The committee is currently implementing FIRMA's changes. Treasury issued an initial set of regulations late last year and will issue more regulations by 2020, early 2020, implementing FIRMA. Of the several areas where FIRMA changed the law, I'm going to talk about 3 of them. First, and probably most importantly, FIRMA significantly expanded the scope of transactions that are subject to CFIUS review. In addition to the transactions I talked about that are covered under traditional CFIUS, my name, FIRMA expanded CFIUS coverage in 4 ways. First, it allows CFIUS to review certain transactions in U.S. real estate by foreign persons. Second, in addition to the investments that transfer control over a U.S. business, FIRMA adds coverage of minority non-controlling investments that grant the investor certain rights regarding the business. For example, the rights to non-public information, sensitive personal data, critical technologies, or critical infrastructure. Third edition under FIRMA, it adds coverage of changes in ownership rights that could result in change of control or granting those rights I just described. And fourth, CFIUS adds coverage of transactions intended to evade CFIUS review. So that 4-pronged expansion of CFIUS jurisdiction is my first area of changes under FIRMA. The second area of changes, FIRMA sets up a new, shorter, and faster procedural option for parties to file transaction with CFIUS. These are called declarations as opposed to the traditional CFIUS notices. And FIRMA also allows CFIUS to make filing mandatory rather than optional in certain circumstances. Third, FIRMA authorizes CFIUS to develop a process to share some protected information with U.S. allies. This is a change that helps to enable international cooperation to address shared concerns and prevent circumvention of CFIUS's protection through other countries. In a similar vein, FIRMA also encourages our allies to maintain their own robust and effective national security review processes to vet foreign investments into their own countries. Their doing so is essential for U.S. national security, and the State Department is directing diplomatic efforts toward this purpose. Now I'll address specifically what L does regarding CFIUS. First, L provides legal advice to policy offices in the State Department. As part of that work, we follow and participate in much of the committee's work, particularly the work that has legal aspects, such as drafting the regulations under FIRMA and reviewing consistency with the CFIUS statutes and regulations. We particularly watch for the State Department concerns. For example, anything related to U.S. foreign policy and diplomatic relations, or the security of our overseas embassies and personnel. Another important responsibility of L is assessing proposed U.S. actions in light of international law. The key international law point, and this goes back to the first half of my presentation, is that U.S. investment treaties, which include the investment protection obligations, also include some sort of exception for national security or essential security. As one example, the USMCA provides Nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for the fulfillment of its obligations with respect to the maintenance or restoration of international peace or security, or the protection of its own essential security interests. The predecessor agreement that's currently in force, the 1992 NAFTA, includes at Article 1138 a national security exception that specifically covers what CFIUS does, a government's decision to prohibit or restrict the acquisition of an investment. Thus, under our investment treaty obligations, CFIUS's screening of foreign investments must be based on national security reasons. There's a parallel domestic law requirement. The CFIUS statute makes clear that national security is the only basis for CFIUS review. This limited focus on national security only is consistent with the United States open investment climate, which supports U.S. jobs and economic growth. So L's work helps to ensure that the committee's actions are based on national security reasons and thus that they remain consistent with U.S. and international law. I'd be glad to take any questions at the end of the session. I'll warn that my ability to answer may be constrained by the fact that the information filed with CFIUS is protected against disclosure, so I can't comment on any particular transactions, including even stating whether they've come under review by CFIUS.
So much, David.
Thanks, Jennifer. Thanks, Jennifer. It's a pleasure to be here. As noted by David, my office, LCID, represents the United States in investment arbitrations. The United States currently has 39 bilateral investment treaties, or BITs, in force, all of which provide for investment arbitration. Additionally, we have trade agreements with 19 different countries which contain investment chapters and which provide for some form of investment arbitration. Now, as David noted, broadly speaking, there are two types of investment arbitrations: investor-state arbitrations and state-to-state ones. For investor-state proceedings, an investor of one state brings a claim against another state, whereas in a state-to-state proceeding, both parties to the dispute are states. But regardless of whether the agreement is a BIT or a trade agreement containing an investment chapter, these agreements provide individuals or companies a right to arbitrate investment disputes. And I put the emphasis on investment disputes because there's no right for individuals or companies to arbitrate trade disputes. Although our modern trade agreements are large agreements with numerous trade provisions, the only arbitration right conferred on the private sector is in the investment realm, not the trade realm. So today my discussion will be limited to investment arbitrations, including L's role in such arbitrations. In my presentation today, I'm going to discuss the U.S. experience as a respondent in both investor-state and state-to-state arbitrations. A respondent is basically the equivalent to the defendant in a U.S. court. Additionally, I'll be discussing the U.S. experience in making non-disputing party submissions. Non-disputing party submissions are somewhat like amicus briefs. In the investor-state realm, the first claim was filed against the United States in 1998, and that was the Lowen Case. And since then, we've defended 17 different investor-state arbitrations, all of which have been brought by Canadian investors under the NAFTA. Not too long after Lowen submitted its first claim in 98, 3 other claimants submitted claims, and these were the ADF, Methanex, and Mondev cases, and we were defending 4 cases simultaneously. We won all those cases, and since then, we've not had to defend that number of claims simultaneously. Over the years, claimants have challenged a variety of U.S. measures. For example, in the Methanex case, the claimants alleged that a California measure banning the use or sale of MTBE, which is a gasoline additive, violated investment protections of the NAFTA. In the Cantfor, Tembec, and Terminal cases, claimants claimed that anti-dumping and countervailing duties imposed by the United States on softwood lumber from Canada violated investment protections of the NAFTA. Another case involved the U.S. closure of the border due to Canadian cattle in 2003 due to concerns about mad cow disease. And in Mondev, Lowen, and two of the Apotex cases, claimants alleged that decisions by U.S. courts, or I should say by courts in the United States, breached investment protections of the NAFTA. Now, Apotex is a generic drug manufacturer from Canada, and it has brought 3 of the 17 cases against the United States, more than any other claimant. Their third case was the most recent case against the United States that proceeded to a final award. Apotex brought that case in response to the FDA's issuance of import alerts regarding 2 of Apotex's manufacturing facilities in Canada. The import alerts prevented Apotex from importing drugs from those facilities into the United States and resulted from FDA concerns about Apotex's manufacturing practices. The case was brought in 2012, and in 2014, the Tribunal issued an award on both jurisdiction and merits in favor of the United States. That was probably one of the faster investment arbitrations to reach a decision on the merits. These proceedings tend to take quite some time. Now, the United States has never lost an investment arbitration, although 3 of the 17 were either settled or discontinued by the agreement of the parties. Of those 3, perhaps the most well-known will be the case brought by 2 trans-Canada companies alleging that Secretary John Kerry's denial of the permit for the Keystone XL pipeline violated various NAFTA provisions. After the change in administration, the State Department granted the permit and the trans-Canada companies withdrew their claims. That case was discontinued in 2017, with both sides agreeing not to seek attorney fees and other costs. The other 2 cases that were discontinued involved softwood lumber disputes from Canada, which were discontinued as part of the 2006 softwood lumber agreement between Canada and the United States. The claimants withdrew their claims with prejudice, and the United States agreed not to seek attorney's fees and costs. So turning to state-to-state arbitrations, the United States has never initiated an investment arbitration against another state, although we have been the respondent in one such proceeding. In 2011, Ecuador brought a claim against the United States under our BIT, effectively seeking a joint interpretation of a provision of the BIT that it hoped to use in an investor-state arbitration. The United States prevailed in that dispute on jurisdictional grounds. Although a lot of states use outside law firms to defend investment arbitrations, as has already been noted, the United States uses lawyers from my office. When we're defending these claims, the work is very similar to that being done by attorneys in law firms. When we receive notices of investment claims against the United States, attorneys in our office will review the notices and typically draft a memo identifying potential defenses. A memo is basically an issue spotting exercise where we assess the defenses that might be worth investigating further. The memo would potentially discuss all phases of the arbitration, jurisdiction, merits, and even possibly damages, assuming that the notices we've received contain enough detail. The next step in the process usually involves constitution of the tribunal, of the arbitral tribunal. Most investment arbitrations have 3 arbitrators, one appointed by the claimant, one by the respondent, and the third is frequently appointed by the agreement of the claimant and respondent, although if they're unable to reach agreement, it'll often be appointed, the presiding arbitrator will often be appointed by an appointing authority, such as ICSID, the International Center for the Settlement of Investment Disputes, here in Washington, or the Permanent Court of Arbitration in The Hague. After the claimant appoints its arbitrator, an attorney in our office will research the background of the arbitrator and draft up a memo summarizing it. If the arbitrator has sat on investment tribunals before, the memo would typically include a summary of the decisions that he or she has joined, particularly for the types of claims that we might consider to be the central focus of the case. Thus, for example, if an expropriation is alleged and the arbitrator has been a part of arbitral tribunals that have issued awards discussing expropriation, a summary of those decisions would typically be in the memo. While all that's occurring, we're also working on identifying who we might want to appoint as an arbitrator, and also who we might agree to be the presiding arbitrator. And that typically also involves the drafting of a bunch of different memos on potential candidates. After a tribunal is constituted, the next step is frequently to agree with the claimants on a procedural and confidentiality order. Usually that involves working with opposing counsel to agree on how the arbitration will proceed. The procedural order typically includes a schedule for briefing and discovery and might bifurcate the proceeding into more than one phase. For example, if the United States has jurisdictional objections, we might agree to have a jurisdictional phase and schedule the briefing of just that phase. Or if the disputing parties can't agree to bifurcate jurisdiction, then we might agree on a briefing schedule to litigate that issue so that the tribunal can decide whether or not jurisdiction should be bifurcated. After that, the arbitration proceeds. There's typically 2 rounds of briefs per side per issue, as well as document production. For many investment arbitrations, the briefs surpass 200 pages and sometimes even 300 pages. And for an arbitration of that size, we may have a team of 6 attorneys engaged both in developing our understanding of the facts, as well as research and writing the briefs. Our office has a chief of investment arbitration, and in the Apotex 3 case, the chief supervised 5 attorney advisors who did the bulk of the brief writing and fact discovery. That involved a lot of discussions with FDA lawyers and FDA technical experts to understand the factual and regulatory background. Now, typically in investment arbitrations, direct testimony is put into the record by witness statement, not by live testimony. And we worked with FDA officials to put in witness statements assisting in the U.S. defense. And we also hired an expert witness, and we put in a witness statement for him as well. The Apotex 3 case was the first case where the United States hired a vendor to help with discovery. There was quite a bit of electronic discovery in that case, so we hired a company experienced in the field to help, although the attorneys still needed to review all the documents, both for relevance and privilege. And by the time we got to the hearing, our team had grown to 9 attorneys and a paralegal. One of the attorneys was the acting legal advisor, and the other 2 who joined us were the head of LCID and her deputy. So that's the U.S. experience as a respondent in investment arbitrations in a nutshell. In addition to defending the United States when it is a respondent, our office also submits non-disputing party submissions to arbitral tribunals. Non-disputing party submissions are briefs that allow a state that is a party to the BIT or trade agreement, but not a party to the investment dispute itself, to submit views on the proper interpretation of the BIT or trade agreement. These submissions are much shorter than the briefs we write when we're a respondent and typically range from 2 to 20 pages. The BITs and the trade agreements that authorize non-disputing party submissions limit them to the proper interpretation of the agreement. Thus, we do not make submissions on factual disputes, nor do we engage with the merits of the claims or seek to advocate for one side or the other. We make these submissions because we hope they will assist the tribunal in properly interpreting the BIT or trade agreement. And in recent years, there's been a lot of criticism of investment arbitrations for a perceived lack of consistency when it comes to interpreting provisions of the investment agreements. And non-disputing party submissions are a tool for treaty parties to help address that issue. Now, our older BITs do not address non-disputing party submissions. However, ever since the NAFTA, every BIT or trade agreement authorizing investor-state arbitration has provided non-disputing parties the right to make submissions to the arbitral tribunal, providing that party's view on the proper interpretation of the agreement. To date, the United States has filed 54 non-disputing party submissions pursuant to a BIT or trade agreement, including 5 last year. 38 of these have been under the NAFTA, 8 have been under the CAFTA, the Central American Free Trade Agreement. 3 have been under our trade promotion agreement with Peru, 3 also with our trade promotion agreement with Panama, 1 under our free trade agreement with Oman, and 1 under our BIT with Uruguay. All of these have been written submissions except one. One of the CAFTA submissions was an oral submission that we made at the hearing. All of the written submissions are available on EL's website. Now, although we have an active practice in making non-disputing party submissions, we don't make a submission in every investment arbitration that is proceeding pursuant to one of our BITs or trade agreements. However, we do make an effort to follow all such arbitrations. For every case that we're aware of, we assign an attorney to monitor the case. That attorney will read the briefs and other documents and sometimes attend the hearings. But the main role of the attorney assigned to the case will be to draft a memo summarizing the case, as well as to draft the non-disputing party submission itself. The memo is drafted first, and it summarizes the facts and procedure of the case, the claims that are at issue, and the provisions of the bit or trade agreement that are in dispute. Additionally, if the United States has previously filed briefs addressing these issues, the memo will discuss that U.S. practice, as well as summarize any relevant arbitral tribunal decisions on point. The memo contains a recommendation about whether we should make a submission, and if so, on which issues. The memo will be reviewed by our Chief of Investment Arbitration and other investment team members, and then we'll go to the head of our office, the head of LCID, for her consideration. At some point in the process, the attorney advisor assigned to the case will draft the brief itself, which goes through the same review process. And if the head of our office agrees, we circulate the brief to our LEB colleagues here on the panel, as well as to the investment office in the state's economic bureau. Once consensus is reached, we then circulate the brief to the legal advisor for her consideration, as well as to other U.S. government agencies that have equities in the investment field. Once agreement is reached with all concerned, we'll submit the brief to the tribunal, providing copies to the disputing parties as well. So that wraps up my discussion of investment arbitrations. And I'll turn the floor over to Emily.
Yeah, please do. Thanks so much, Sean. All right, Emily will round us off with a discussion of it.
Thanks, John. So as Jennifer mentioned in her opening, successive administrations, including this one, have deployed sanctions as a key tool for applying economic pressure in response to national security threats and in service of our foreign policy goals. It's probably no surprise that the sanctions practice at state is highly dynamic and increasingly fast-paced. EL plays a key role in advising policymakers on both UN and US sanctions issues and interfacing with Treasury and interagency colleagues, as well as foreign governments and outside groups. Whether it's Iran, North Korea, Venezuela, or GLOMAG, each sanctions program has its own array of statutory and regulatory authorities, as well as international law considerations to take into account. And new authorities and designations have been rolling out at a steady clip. I'll start with some brief background on sanctions and the legal framework in this area, and then turn to EL's role and some of the recent issues that we've been working on. So taking a step back, what are the goals of economic sanctions? First, sanctions generally seek to compel changes in behavior by imposing costs that can change the incentive structure for bad actors and their supporters. Second, sanctions seek to constrain activities that by making them more difficult, by cutting off funding or materials. And third, sanctions provide a strong signal that we believe certain actions are wrong and will back up our words with real-world consequences. Where the international community is united in a particular area, the overall impact of sanctions can be maximized and they're most likely to achieve their goals. So a UN sanctions regime is really the gold standard from that perspective. To take North Korea as an example, over the past few years, we've had an increasingly restrictive UN sanctions framework together with US national sanctions and other countries' national sanctions programs that have increased the cost on the regime in response to its illicit weapons programs. Sanctions have operated as substantial constraints on the regime's access to funding, trade, shipping, and materials for those WMD programs. And sanctions have sent a strong and unified message in support of North Korea changing its behavior and pressing it to engage seriously in negotiations on denuclearization. In other cases, a UN framework might not be feasible, as is the case with Russia-related and Syria sanctions, but we still work through state and treasury with our allies and partners to try and create a force multiplying effect that can make it much harder for sanctioned persons to move large quantities of funds around the world or to obtain goods, services, and technology for their activities. So what's the legal framework in this area? Each sanctions program has its own specific set of legal authorities, which are designed to address the specific country or activities of concern. And these authorities are often layered on incrementally over time, which can make for a fairly complex domestic and international law landscape. And that often requires careful consideration before advising on as a lawyer. But the types of legal authorities in place in this area share a number of common features, and we regularly see that updates in one regime will then lead to similar changes in others. So in some programs, the UN Security Council, of course, has adopted a binding international law framework for sanctions through one or a series of resolutions over time. And there, the US domestic sanctions authorities have to extend at least that far, although the United States typically treats UN sanctions frameworks as the floor rather than the ceiling in terms of what the options are for sanctions. US domestic sanctions authorities are implemented primarily through executive orders, which are issued under the International Emergency Economic Powers Act, or IEPA. IEPA gives the president broad powers to deal with extraordinary threats to the national security, foreign policy, or economy of the United States. And when the president declares a national emergency, there's the authority under IEPA to block or regulate transactions concerning any property subject to US jurisdiction in which a foreign person has an interest. And the president may prohibit US persons from engaging in any types of transactions concerning that property or impose other economic restrictions in relation to those persons, like a ban on exports or new investment in a particular country. In addition to executive orders, Congress has had an increasing and strong interest in sanctions, and there are now many sanctions programs that have a legislatively mandated component. We often get questions, particularly from foreign practitioners, about what's perceived as the extraterritorial reach of US sanctions. So it's worth emphasizing that US sanctions authorities apply directly only to US persons or property that are subject to US jurisdiction. So for example, primary US embargoes that apply to transactions involving certain sanctioned countries, such as import and export bans that are applicable to Iran and North Korea, are straightforward geographic trade restrictions that regulate the actions of persons and property that are subject to US jurisdiction, US persons and US origin goods. Similarly, even where US sanctions designations are triggered by activities of a foreign person that are taking place entirely outside of the United States, the sanctions measures that are imposed are still regulations that apply to US persons and property that are subject to US jurisdiction. So to take an example, if the United States imposes blocking sanctions on a Russian person who's involved in selling oil to the government of Syria, the effect of the action is that the property of the Russian SDN that's subject to US jurisdiction is blocked or frozen, and US persons are prohibited from engaging in transactions with the SDN. Where the United States imposes banking sanctions on foreign financial institutions, for example, we have banking sanctions that apply to banks that knowingly conduct significant financial transactions with the Central Bank of Iran. The effect of those sanctions is that US banks are prohibited from allowing the foreign financial institution to maintain certain types of bank accounts in the United States. Again, a consequence that's occurring within US jurisdiction. And finally, some sanctions authorities provide for what are called menu-based sanctions that are chosen from a list of options, or the menu. Each option on the menu has a clear nexus to US jurisdiction. For example, restricting federal agencies from procuring goods that involve an SDN, or requiring the board of the Export-Import Bank to deny the SDN access to credit. A final general point is that sanctions are not intended to be permanent. The goal is to change behavior, and they typically can be adjusted or lifted where a person or government takes concrete, meaningful, and verifiable actions to address the concerns that led to the sanctions in the first place. So blocking of a person's property is only a freeze, which is something we emphasize, and that freeze can be lifted. Sanctions authorities themselves are designed to be flexible and allow for adjustments to be made when appropriate, including the possibility of licensing or exceptions to calibrate the impact of the sanctions and avoid unintended consequences. So many of our sanctions, for example, include exceptions for trade in humanitarian goods and services, as well as the ability to issue waivers and licenses for activities that align with U.S. national security interests. So what's L's role on sanctions? I often get questions from folks outside of government who are surprised that state even has sanctions lawyers because they assume that Treasury lawyers do all the work. Well, we do work very closely with colleagues in the Treasury's Office of Foreign Assets Control, or OFAC. L has an important role in its own right in the U.S. government's sanctions efforts. L work on sanctions falls into roughly 4 areas: new authorities, implementation of existing ones, strategic advice, and engagement with foreign governments and outside groups. Within L, sanctions work is divided by programs among attorneys, and my primary expertise is on counterterrorism, North Korea, Syria, and Africa sanctions. With respect to new authorities, L's work involves supporting the development of new sanctions authorities to respond to emerging or persistent national security or foreign policy threats. This work will often result wherein State Department officials will seek tools to create new incentives or affect change on the ground. It can include support for negotiations on UN Security Council resolutions, working with colleagues that we have in the Office of UN Affairs, and highlighting issues that can arise if a UN sanctions regime is to be implemented domestically. It can also involve engagement with the Hill on new sanctions legislation, which from our perspective is often focused on making sure that the executive branch can maintain sufficient flexibility to use sanctions to accomplish our foreign policy goals. For example, mandatory sanctions provisions can be somewhat unwieldy as they may not provide enough flexibility to respond to a dynamic situation or to further the goals of the underlying sanctions. So L will work with other executive branch clients to try to make sure authorities are crafted carefully, target the appropriate underlying conduct of concern, and contain appropriate waivers or exceptions. L also has a key role in the interagency group that works on the drafting of new executive orders, including framing new designation prongs and other restrictions. And the Venezuela program is a particularly active area right now in that we've had 5 new sanctions executive orders in the past 2 years. Second, there's the day-to-day work of implementing sanctions. There's regular rollouts of new sanctions designations, which involve developing and reviewing designation packages and helping policy offices understand the legal risks or implications of particular actions. Treasury has the primary designation authority under most sanctions executive orders, but state also has the lead on designations under some authorities, including the counterterrorism sanctions under Executive Order 13224. There's also certain types of sanctions actions that implicate areas of particular L subject matter expertise. For example, sanctions where designations are provided for serious human rights abuses or certain cyber-enabled activities. And our implementation works also involve collaborating on licensing and waivers where appropriate, where we're seeking to mitigate unintended consequences of sanctions or to further our national security interests. In the third bucket, we provide strategic advice to our policy clients about sanctions options, both including options to increase pressure on particular actors if we're anticipating an event of particular concern or in response to particular developments on the ground, options for standing up new sanctions programs, and options to consider adjusting or even unwinding different sanctions programs. So we help senior policy officials identify potential impacts of certain actions with respect to sectors that may implicate international obligations, and also where sanctions determinations may affect our ability. So another issue that comes up is instances where sanctions might affect our ability to take certain actions like foreign assistance. So providing internal advice to the State Department on the implications of our own actions in the sanctions space. And then the fourth bucket, which I mentioned earlier, is engagement. So translating the U.S. sanctions regime and our approach to sanctions with foreign government counterparts. So we have regular meetings with foreign legal offices to discuss sanctions issues. And then we also help support outreach with private sector actors and other organizations. And a recent example of where we've been working on outreach to the private sector and outside groups is in shipping. So we worked recently with policy offices and Treasury on new shipping advisories that are providing guidance to the shipping industry including insurance companies, flag registries, and other private sector actors on some of the sanctions risks that are involved in their industry, particularly in light of North Korea's engagement in illicit shipping practices and also Iran and Syria-related sanctions risks. So I'll stop there so we still have some time for questions.
Great, so thank you so much. Before we turn to questions, I just want to ask you to join me in thanking my colleagues for these extremely rich and thoughtful and discussions, and I think they give you completely different subject areas, but they give you a real sense both for the complexity of the issues that we're dealing with now in these economic matters, and also the range of experiences and activities that we get into. So thank you all. All right, and then Rosa, are you going to help us with taking questions?
Thank you so much for all of your remarks. I wanted to remind, especially our online viewers, that we are receiving questions online at rightfrommel2019@gmail.com. And we're also going to take some questions from the public. And to start the discussion, I have some questions also for each of you. One of them is for Jesse Thunder, actually. When we think of civil aviation law today, and when we think of international law today, it's very difficult not to think of the very high-profile plane crashes that we have seen happening in the last few years. And it would be great for you to discuss if this has international law implications or if the Office of Legal Advisor has a role in any sort of response or reaction when a crash happens, especially a crash with international repercussions. So that's one question. For David, I thought it was fascinating, the CFIUS discussion that we had, and you mentioned a lot the element of control. If you could talk a little bit about how you assess control and the criteria that guides this would be great. For John, it would be great if you could share with us some thoughts or some views the Office of Legal Advisor has on all the reform discussions of investor-state dispute settlement at this particular stage. For Emily, in terms of economic sanctions and international law, is there specific criteria that is very important for the Office of Legal Advisor to consider when you're thinking of determining whether economic sanctions are applicable in a particular scenario? And for Jennifer Newstead, I wanted to ask you a question, thinking of a lot of our students. We have actually a lot of young students here that are molding their careers in international law. For them, this is the kind of career that they want to have. They want to be at the Office of Legal Advisor, they want to be working on international economic law issues, and you referred to the interconnectedness, right, of the global economy. And I think it would be great if you could share some thoughts of what you think makes an effective attorney working at the Office of Legal Advisor on international and economic law. Thank you.
We'll go in order.
Yes. Yes.
Great. Well, I appreciate the question about crashes. Obviously, just from a human perspective, they've been very, upsetting and major incidents. And I think the departments as a whole have been. I mean, the Department of State plays a role in responding to the crashes in terms of, if there are American citizens involved and so forth. And in some of the investigations, use our agencies, FAA and NTSB often get involved. So, but there hasn't been a lot of work directly on the international law. It doesn't really affect kind of the traffic rights that I mentioned or other issues. But, there is this other kind of framework that I really didn't have time to get into about the safety cooperation. And, as I mentioned, FAA is really, we all work, I think, a lot with other agencies and all the different work that we do in L, just reflecting how state kind of has its fingers, in everything. And but FAA really is a major repeat player when it comes to international agreements and cooperation, which just makes a lot of sense. The FAA, has an interest in seeing the rest of the world kind of raise its standards. So they provide technical assistance to other countries or with kind of countries that are on a similar level, do cooperative agreements, and in terms of like safety certifications of parts. So, the kind of direct response to the crashes, I think, are handled more through the, more like diplomatic or agency to agency kind of communications between FAA and its international counterparts. it'll be interesting to see kind of what ripple effects these types of crashes have on the kind of cooperative or technical assistance agreements that we have. And, so that's a long answer to, I think, an important question, but for better or worse, it hasn't involved a lot of work.
Great, thanks, Jesse. I'm going to address your question about control in CFIUS and how CFIUS assesses control and what are the criteria to determine control. And I think it's a great question because in traditional CFIUS, everything that CFIUS does with a transaction turns on a determination of whether the transaction involves control of a U.S. business. And that word is put out there by the statute and not defined in the statute. There are a lot of different ways to look at control of a company in different areas of law. CFIUS, you can look at ownership, you can look at participation in management, a lot of different things, but CFIUS has a different purpose, and so it has its own definition of control. I'm going to give you the lawyer's answer, which is you can look up 31 CFR 800.204, and that's the definition of control. But I'll talk a little about that and how that works. But if and my copy of it is significantly marked up with, because this is something that we refer to quite regularly. But basically, the definition of control for the purpose of transactions under CFIUS is whether it gives the transaction gives a party the right to make significant decisions regarding the business. And the statute, the regulation lists 10 indicia that would indicate control. If the person acquiring a share in a business, for example, has a role in the appointment or dismissal of officers or senior managers, that tends to indicate control. Entry into new lines of business, closure of the business, things like that, major business decisions. So if you get to do those things, those tend to indicate control. The regulation also gives 6 minority powers that it says do not indicate control. So for example, if you have the power to prevent the amendment of the bylaws of a company as a minority shareholder, that doesn't mean you have control. That just is a minority shareholder protection. And then the regulation goes into 9 examples and says if this happens, this would be a situation of control. If this happens, this would not be a situation of control. But as an overview, that's how CFIUS determines control. It's something that we look closely at in a lot of transactions and determine whether it in fact does involve control. And the regulation's got all the details. Okay, thanks.
Well, I'll address your question about investor state reform to the extent that I can. You're certainly right that there is a lot of discussion of reforming the investor state system, if you can call it a system. Reforms are being discussed in 2 international bodies, UNCITRAL, the UN Commission on International Trade Law, and in fact, our chief of investment arbitration is up in New York this very week, right now, discussing with probably 90 or so some other states potential reforms. The other international organization where reforms are being discussed is ICSID, the International Center for the Settlement of Investment Disputes. They have a meeting this Sunday to Tuesday, which I'll be attending as part of the U.S. delegation, discussing the reform of arbitration rules and mediation rules and other related rules. So there's quite a lot of activity. There is a wide variety of views amongst the states. Certainly we're open to some reforms. The EU has probably proposed the biggest reform, which is to do away with arbitration and make it, maybe that's an overstatement, but to have a permanent investment court instead of constituting ad hoc tribunals. What reforms the United States is open to is the subject of high discussions by high-level policy officials and They're still ongoing, so I'm afraid that I'm not able to say where we're going to come out on all the reforms, but it's certainly a role that our office is participating in both the two international bodies. I think that's all.
And so in response to the question about sort of what sources of international law do we look to in the sanctions space, as I mentioned, there are the UN regimes, and so a fair amount of time is spent kind of where there is a UN regime. North Korea is an example where you have a very broad UN sanctions regime, sort of working to harmonize what our view is of the UN regime and the domestic regime. And when you look at a given fact pattern, sort of working through how should a particular set of circumstances be addressed both at the UN and domestically. If you're moving to the 1718 committee and you're seeking an exemption from sanctions at the UN, you would need to be able to take steps domestically to allow for the same activity. The other way in which international law comes into play is with some of the designation criteria. So some of the U.S. sanctions programs refer to gross violations of human rights, serious human rights abuses. And so in those cases, we work very closely with colleagues who work on human rights law issues to coordinate with them on review of packages and making sure that the decisions we're making in the sanctions space align with our international law views on human rights issues. So those are two examples.
Great, and I'd be happy to answer your question. In fact, I'm glad you asked it because I think you said there are students who might be watching, who might even be in the room or interested in potentially making careers in L. The first point is that's fantastic. We always encourage and want, we hope that students will think that way and others will consider that. One of my predecessors was fond of saying that L is the greatest international law firm in the world and talked about the extraordinary and unusual ability to practice international law and also work on domestic law issues where they relate to our foreign policy and national security in the way that we do. I think it's fair to say we all agree, and our colleagues agree, that we're very fortunate to be in the roles, but also that this is a wonderful place to make a career. But you asked about what particular set of skills might contribute best in this area, international economic law. My view, but I'm going to invite my colleagues who are sitting here to comment also, is we pride ourselves in L on being generalists. So to start with that, I don't think it's necessary to join us with particular expertise beyond that which all the L attorneys have in terms of outstanding legal and professional skills in these areas. You can develop it in the office. You can develop it through work on the issues over time. But obviously, an interest in these broad themes we're talking about today of how international law and economic activity, how important it is that we continue to develop stable regimes internationally that can contribute to economic growth, development, strategic objectives, national security in a way that's consistent with law and that's ideally something that can be multilateral and bilateral and needed and operate that way is very important. My own view is beyond that basic commitment to our mission and interest in that mission, I think everything else for the very high quality of attorneys that come to our office can be learned. But I'll let my colleagues correct me or add if they have any views on this. I'm sure they'd be interested in your thoughts too.
One of the things that I guess I wasn't expecting before I joined the State Department was how much we work with other agencies, even though, like in the sanctions area, Treasury may lead. In trade agreements, USTR will be the lead. But for investment arbitration, state may have the lead. But for all these portfolios, we're working with all these different other agencies, and you really, not only do you have to be prepared and be thorough and just be a good lawyer, but you really have to be able to work with other people who have different interests than yours. The U.S. government rarely makes a decision within one agency by itself, particularly in this area. It's coordinated with different agencies, and you need to be able to work with other people and be able to find a consensus, a compromise, or something, because it was really an eye-opener to me when I joined the State Department. And I think in every office that I've worked in, every issue, you're working with other agencies. So.
And the one other point I'd just add, Jennifer made the point about generalists, but not everyone folks who aren't familiar with L might not know that our office is structured with a rotation system. So we spend a few years in one office and then move, and so it's actually you can develop very broad expertise and have a very broad range of experiences within state. So from, one office to the next, and then sort of bringing those skills around. So anyway, just thought I'd add that.
I'll just add one thing, which is that we have a variety of backgrounds of lawyers in L, and there are a number of people who came straight out of law school, which is great, but there are also a number of people who've done other things before law school. So I wouldn't say you have to go straight from law school to L, and if you bring experience from a private firm or from another government agency or an NGO or whatever, an international organization, to L, I think that can be very useful. So I would say, a variety of backgrounds are welcome and in fact beneficial to our office. I worked at a New York law firm for a very short time and then worked for the Treasury Department for about a year before I came to L. And I found that background was useful here. So I would say there's not one specific way to get there. There are a lot of different possible paths.
Thank you so much for that insight. I would like to open it for questions from the audience.
So, Jesse, I'll pick on you. In December, Virgin Galactic actually managed to put people into space through their commercial space program. In the space law community, more than 60 years ago, L famously chose not to make an argument when Sputnik was launched that sovereignty extended up into space and that would have international law implications if you orbit a satellite. But now we're actually seeing the commercial side of this where launches might be crossing borders, where you've got civilian access to space that's changing in a way that kind of cries out for regulatory structure. We've seen some laws be passed through looking at space mining specifically, but there's talk this year that the first paid flight for space tourism might happen from Virgin Galactic. Is there any sense of kind of building off of FAA or civil aviation regulations that there's got to be someone looking at how do we regulate this and what happens when we've got these things going into orbit from the United States or with US citizens from other countries, et cetera?
So I think one of the great skills you learn in L is when to not try to comment on subject matters that you don't work on. So I mean, those are fascinating questions, and I'm personally interested in them. I think the whole new kind of era of space travel and space commerce is really exciting. But once you get into the upper atmosphere, we hand things over to our colleagues in the Office of Environment, Ocean and Environment and Science, LOES. So my colleague Gabriel Swinney is a man to talk to. So I think we can provide his contact information. You can follow up with him. Yeah. So anyway, I mean, it is fascinating. One of his predecessor, left L to work for Brad in Israel, worked for asteroid mining. So occasionally in L we get poached, not too often. But anyway, so sorry I can't comment directly on the question, but I'm going to take the fifth.
I'll just add a slightly extended non-answer to your excellent question. And I agree with everything Jesse said about the wisdom of us saying not a lot now on this until there's specific things we want to say. But generally, I would just add that, of course, we're very seized with the same questions that you're asking and interested in them. That in the context of space and also domains like cyber, where the rules and the traditional international law approaches are much less clear, we're obviously thinking all the time and talking to our colleagues in our agency and otherwise about it. We've thought about having that be a topic for this sort of presentation at some point. So again, I'm going to join Jesse in not getting into details now, but I'm glad you asked because it's something it's quite topical and on our minds.
So I'm going to build on the space theme for just a second to plug an event that Carnegie Endowment for Ethics and International Affairs New Leaders Program is having next week on ethics and space. So if anyone's interested in that, I can talk to that too. But I wanted to come back to Earth for a moment. Jesse, you spoke to kind of reciprocity that we look for in the Open Skies Agreement. So if one country will do it, if another country will do it. I was wondering if that type of thing plays into CFIUS at all, where we'll have less of an issue with or not review say if a British person wants to invest, as long as if an American wants to invest in Britain, I suspect that that probably wouldn't play for some countries, but for some that are seen as close allies, we might not have an issue with that. Is that considered at all in CFIUS reviews?
Okay, thanks for that question, which I'm happy to address. It's less of a legal question and more of a policy question, but I would say the answer is yes to an extent. So we do, to explain, I think I said there's a national security interest in our allies having similar investment screening mechanisms for national security. And the reason for that, I think, is pretty straightforward. If the U.S. has a company that makes some kind of widgets that are needed for our fighter planes to make them better than our rivals' fighter planes, and there's another company that makes those same widgets in Germany, and I'm being intentionally very vague about what this is because I don't want to have a specific example. But there's another company, a second company in Germany that makes the same things. And let's say our military rival country tries to buy the US company and CFIUS says, no, that's needed for US national security. Then if Germany doesn't have an investment screening mechanism, they could just go and buy the German company and get the same technology that we had tried to prevent them from having. So for that's sort of an example of where it's important to us that our allies have comparable, not necessarily the same, national security screening mechanisms on foreign investments. And so I wouldn't say it's a reciprocity issue, but it's sort of a mutual protection issue that we have similar national security interests, so we should be looking at similar issues. And I think we're now doing more cooperation with our allies on those sorts of mechanisms. Does that answer your question? Okay.
Hello, good afternoon. My question is it could be Jennifer or whomever wishes to answer. Are there any opportunities in your office, let's say for foreign trained attorneys that, with an LLM and with the proper bar certification to develop the career in international law?
I'm very glad you asked. The short answer is yes, and I'm going to see if one of my colleagues would like to elaborate a little bit on any specific parameters we can talk about now. If not, no. Why don't you see us after? We'll follow up with you. But yes.
Do we have other questions? You have a question?
Okay, I try not to violate the one question. For Emily, I was wondering with respect to sanctions, whether considerations of smart sanctions, one of the detractors of sanctions often say the humanitarian effect is really, really bad. So if you apply smart sanctions, more targeted sanctions, those tend to have less of a humanitarian impact, but also tend to be less effective. Does that come into play at all in considerations? Is it actually something that's considered under international law or from a legal perspective, something that is considered as you're developing and implementing sanctions regimes?
So certainly the potential humanitarian impact of sanctions is something that we consider, and I would say our programs have, in general terms, have exceptions, licensing, authorizations, both in respect of humanitarian assistance and trade in humanitarian services and goods. And so that is absolutely something that we take into account, both in respect of some of the broader country-based sanctions programs. And then, as you mentioned, there are some more targeted sanctions programs that we have that focus on sort of particular actors in a particular area. But that's certainly something that arises across programs and that we
Question. Time to close, and I want to thank Oh, we have one more question.
Time for one more question. Okay, thank you very much. Thank you very much. I'll try to be brief. So my question goes to Emily, and regarding the sanctions program, does the Department of State have any mark for the threshold of coercion within the meaning of the principle of non-intervention to establish sanctions? Namely, is there any threshold established by the Department of State that a determined sanction could not cross, especially in cases of sanctions that were not analyzed by the United Nations Security Council, such as the ones on Venezuela and Syria? Thank you.
So in terms of sort of thresholds, as I mentioned earlier when I was sort of laying out what the basic authorities are, all of the sanctions relate to regulations that apply to U.S. persons or U.S. goods or have some kind of nexus to the United States. And so from that respect, there's not a non-intervention kind of issue that is implicated. You know, our view is that these are regulations that apply in relation to, they have some kind of nexus to the United States. So I don't know.
I think it's time to close, and I want to thank our speakers today, Jennifer Newstead and Jesse and David and John and Emily. Thank you so much for being here. It's been an honor to host you, as usual. And I also want to thank all of our online participants and also our live participants who have devoted their time to us today. I want to thank the ABA section of International Law and ASIL, especially Ron Bethauer, Renette Gabler, Lauren Mesk, Mark Agoras, and Wes Rist for really collaborating and making sure that this event could be possible. I also want to thank Selena Davis, who's a very instrumental person in putting together these events. I also want to thank our media and communications team, and Cyprian in particular, who really does a fantastic job with this event as well. Thank you all. It's wonderful to host you at GW, and have a good day.